Welcome to False Claims, Real Consequences.
Welcome to False Claims, Real Consequences with Stephen Teller. If you're experiencing discrimination or retaliation at work, the most powerful thing you can do is start documenting carefully and consistently. I'm Lisa Mosby, your host, and in this episode, we'll walk through exactly how to build a record that holds up legally, protects your rights, and helps your case if it comes to that. Hey, Stephen.
Hey, nice to see you.
I'm going to call you Steve for the rest of the show because we're both being casual today. It's great to be here with you. You know, when someone starts to feel targeted at work, what's the first thing they should do?
Well, I mean, it's not a self-serving answer, frankly. Call a lawyer, right? Educate yourself a little. If you can't afford a lawyer, look on the internet. Describe your problem. AI is great. It'll get you halfway there. Do some research. Call a lawyer and find out what your rights are and what's going on. And I think what they're going to tell you in part, you're facing performance discipline. Let's not give the employer any more excuses, right? A wonderful posture is to think about it like, even though they're attacking me unfairly, I may have lessons I can learn. Let me find them and learn them, right? I mean, that way you're not in this totally adversarial posture with your employer. You're saying, okay, what can I do? And they'll see, your interest in trying to keep the job. So don't give them any excuses. And then, you do have to push back on the documentation. Amazon, for example, and I think it's spreading, they're creating documentation for a while before they even tell you you're on a performance plan. And then during the plan, they're creating the documentation. So when the manager writes back and says, you missed the deadline, if you didn't, you better send them an email that says, well, wait a minute, I didn't miss the deadline. And keep track of what's happening in documents is helpful.
And Steve, you mentioned documentation, but what kinds of documentation are the most persuasive in the workplace discrimination or retaliation case?
It's really interesting. I've done a lot of work with people who've been in tech, right? I mean, Seattle. So we've got years and years at Microsoft and others, and they would call me and they'd say, you can see the discrimination right here in this half-inch stack of emails if you just read it for. No, you can't, right? I mean, nobody says, hey, I don't like your kind, or hey, you wouldn't sleep with me, so you're fired, right? They say, they use their acronyms and they describe the performance problems, they ignore the real reason and they bump up some other stuff. So I'm not sure if I answered your question, but it's what comes to mind.
What comes to mind is it depends. Hear so many lawyers say it depends because there's so many different avenues that things go, and it's not always crystal clear. And I think that's why it's so important to work with an attorney who is well versed in all of the rules and all the nuances. Can you tell us, or can you walk us through how to document verbal interactions, especially when the tone or the behavior can't be captured in writing?
Yeah, great. I mean, there's a few ways. Um, One thing you can do, you don't necessarily have to document right back to the person in the interaction, right? I mean, if my boss comes in and yells at me, I could email my boss and say, today you came in and yelled at me. Or you've created a record that occurred, but it's a little obvious and a little clunky. What if you emailed your friend, or texted your friend with whom you otherwise, not your deepest friend you share everything with, right? But your acquaintance, maybe a workplace person, maybe not. And you say, I'm having a tough day. My boss just yelled at me. Now you've created a more natural documentation. You see what I mean? Or you bury, hey, thanks, boss, for coming in and giving me that guidance. I really appreciate your feedback. It was at this point a little harsh, but on this other topic. And so I really prefer if you not raise your voice that much to me, and then you bury that in what we call it. Am I allowed to say it's a shit sandwich? The good thing, the bad thing, the good thing. And you can use that with documentation too, so that your real memorialization is buried in the middle of a longer communication.
The bottom line is it's important to document it. Start keeping track of the dates and times and when these things are happening. How often are they occurring? What are the do's and don'ts of using like email or performance reviews or maybe a company message system? Can they be used as evidence?
They absolutely can. You have to track it. Lots of companies are deleting that stuff pretty quickly. You can download stuff that comes across your desk legally, but the company will wonder, and they may have an agreement that says you won't download things. So you might need to take out your cell phone and take a snapshot of your screen instead of downloading that email or that Slack message. Um, do it clearly, make it square, don't do it way back here so I get the whole background. You're creating evidence, you might as well, create it clearly. And that's one way. You can do a diary, right? You could write a serial diary to your lawyer, then it's attorney-client privilege. Now you're communicating stuff, and you could waive that privilege if you want to later. So there's lots of great ways to do it.
Okay. And then how should someone handle documenting incidents if they're still employed or worry about retaliation?
Yeah, this is all, thinking about it while still employed, and retaliation is a factor, right? You have to think about, well, what's protected activity? So I really encourage people to understand their rights. Well, most states are employment at will. So you need to know what's legal to retaliate against you for and what's not, first off, right? And then, second, in considering whether I want to complain and make a complaint about protected activity or something else, I want to think about the possible impact that it's true that it's illegal to retaliate, but it may anger the boss and they may retaliate and hide it. And now you have to prove the retaliation was the real reason and not your alleged tardiness or whatever they're claiming. So, yeah, it needs some subtlety.
Well, when somebody might be exposed to or experiencing retaliation, what kinds of things would retaliation look like? I don't know that it's always obvious. Sometimes it's subtle. Maybe they're cutting their hours or they're not allowing them to have breaks or other things of that nature. Can you expand on that based on your experience?
Retaliation can be almost anything, right? It can be actionable. In other words, you could sue over it if it's a whole bunch of little tiny things, creating a hostile work environment. Any kind of adverse employment action, like a hostile work environment or a bad review that's tied to your bonus, and obviously discipline, suspension, a performance plan, pending termination, things like that can be things that happen when one triggers, management to be upset about something. Um, and the difficulty, of course, is proving that it's really the protected class or protected activity that caused the problem, right? I can say, hey, boss, you're a jerk. And the boss can retaliate against me for saying that. Not illegal. But if I say, hey, boss, stop touching my butt, then the retaliation is illegal. And it doesn't mean it doesn't happen. The retaliation doesn't happen. But at least if we're tracking that this day I complained and the next day I got suspended, that's, we conclude causation through that kind of timing. Sometimes people say things, I'm mad at you for that thing, right? If they don't understand that it's protected activity, managers sometimes just tell you, you should let me, cheat the customer this time, right? Obviously, no one would say it quite that way.
Hey, how can someone tell the difference between documenting a hostile pattern and simply collecting workplace drama? I mean, you kind of went into it a little bit, but there are distinctions.
Yeah, I mean, the problem is that the distinction is the motivation behind it, not the content so much, right? Workplace drama that's super hostile and awful might be illegal or it might not, and it depends on why it's happening. If it's happening because the boss doesn't like your kind, well, it's probably illegal. Or because you oppose something that you had a right to oppose, it's probably illegal. But if it's just drama because she doesn't like me and I don't like her or whatever, then it's a real minefield. It's risk. Management can say, you're fired. I don't care if it's your fault or not.
What comes to mind for me is the feeling. Like sometimes we know we might feel uncomfortable, how somebody is approaching us, or like you said, touches somebody's butt or back or a touch that's inappropriate. And if when you're starting to feel uncomfortable, what kind of actions can you take? Is that the time you seek an attorney? Is that the time you start documenting? Give us more about this process on if we're not feeling quite right, not secure in our work environment, what are some significant steps that we can start to take?
Well, I think first off, check in with your support system, right? If you're wondering what's going on, you're not quite clear, talk it through with your friends and, parents and people like that who might say, yeah, that's not normal, right? Check in with lawyers. But when you have that vibe, try to identify why. what is it about his interactions or the way that she treats me that is making me feel that way? Because if it's, those offhand comments about, I don't know, not quite your politics, right? But on the edge of, because political speech is not usually an illegal motivation, right? But it's always rife with risk, right? Now we're talking about immigration issues. Are we talking about race issues or not? You know, so we want to listen for those things that make us think, why am I uncomfortable? Well, it was right after I told him, no, or right after I pulled away when he put his hand on my shoulder or something. And that's when the retaliation started. Um, so I think that's important. Let me say something on a little different tone too. Sometimes people with boundary issues can be taught. So if someone's making them uncomfortable, and sometimes the great thing to do is to go to them and say, hate this, that makes me uncomfortable. Could you give me a little more space? It's me, not you. I mean, whatever you need to kind of say to make it okay. Many people will respond appropriately to that um, if they're brought to it carefully.
And doing that in private, maybe,
Yep,
right, rather than public humiliation.
that's right. What's the form of the complaint? It's equally protected activity if I go to him and say, hey, I'm uncomfortable because of, and then you insert that protected class or protected activity, right? That's protected. If you verbally complain or oppose, it's equally protected as an email to HR. But they will have different consequences. And so we better game those out. Usually HR will say, oh, we'll investigate right away. And they'll do an investigation. And after a little while, they'll come back and they'll say, it's fine. We didn't find any discrimination. Right. So how do we use that in an individual's case? Because they're not going to usually come in and say, you're right. You were being mistreated and we have to fire the person. They don't usually do that. Or at least those people don't call me, right? I have a selection bias. Who calls and asks for my help? Yeah.
Can you share a case you won involving a workplace discrimination where strong documentation made the difference in the outcome?
This is kind of an interesting story. It's a little old school, but it's really interesting. So at the beginning, kind of early in the internet era, I don't know if you remember, lots of people would put a little thing on their footer, the signature line, and it would say, please consider the environment before printing this email. Well, my client early in email, he did. And he printed only those really important emails. And he had a half-inch stack of email that he had kept and a fax, with the line, the printed date line right across the top. And I was asking, he had been fired in the middle of the day and they took away the company car. So he was stuck, at work, 2 hours drive away from home, and they took away his car. It was a disability discrimination case. And so I had the manager who had made the decision, on the stand, and I asked him to look at the fax cover sheet and to pull off the staple and look at the line. Those of us in our generation may remember, top of the fax, it's got the line of when it was printed, when it was sent. And it was that same day, after denying that he had done, he'd sent the guy home. So, you can really catch people with a document when their story they're telling themselves is different. That manager didn't want to believe he'd be the kind of guy who would send someone home in the middle of the day. So he wasn't in his testimony. He just wasn't. He didn't mean that he was lying, I don't think. He was caught in a lie because he believed his own truth instead of reading the documents.
That's a great analogy. I like how you've tied it all together. As we close out this episode, are there some final steps that you want to share with folks if they're considering moving forward or actually finding out what their rights are? What should they do? Should they reach out to you first or start documentation first?
I think it's always good to do your research first. People are always, I do a lot of education about this, what's legal, what's not legal. Right? What are the exceptions to employment at will? I did a different podcast with it. It's super important to understand that because otherwise, as you say, we trigger off of those, oh, it's workplace drama. And we think that things need to be fair or that, our performance needs to be judged fairly. And that's not the law. So I think early education, including, pay for a consultation if you can afford it, because it's going to be worth it. If you can't afford it, call a whole bunch of lawyers and just tell them the story. And you'll, spend half a day maybe talking to a couple of people, but you'll get a little bit of feedback about what's going on. So ideally, talk to the lawyer first, sure, if you can afford it. If you can't, do the research. What are exceptions to employment at will? What's illegal here in my situation? And start that documentation early. Yep,
Great. Thank you so much for your insights today, Steve.
it's a pleasure. Thanks.
Yeah, you're welcome. Documentation is your shield and your voice, especially when the system tries to ignore you. If you're dealing with discrimination or retaliation, don't wait to protect yourself. Visit stellerlaw.com to contact Steve directly and get the clarity that you need. And be sure to subscribe to False Claims, Real Consequences for more practical tools and legal insights to help with real people issues. And we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.